the unreliability of data, the gaps in the data, are things that have plagued us for a very long time. And one reason for this is the ineffectiveness, I think, of the RTI system itself. If you look at the Right to Information Act under Section 4, every public institution has to be compelled to put certain data on a website. Having been in Odisha for over 2.5 years as Chief Justice, I must share with all of you that the annual reports of the Odisha High Court were invariably released in the months of February of the following year, which meant that January to December statistics could actually be compiled, analyzed, and put out within a month. This is possible because you start doing this exercise through the year. The Chief Justice of the US Supreme Court brings out a status of the judicial report on the 1st of January of a year, which means they're up to date on their statistics through the year. So this gathering of statistics and putting out statistics has to be an exercise that is continuous, and for it to be meaningful has to be out at the earliest point in time. Second, we must not focus our attention. Of course, prisons are a main focus of attention, but we must also look at the broader picture of detention in the country. Today, you have detention centers. I'm talking of the NRC exercise that has happened. There are, in fact, detention centers in Assam, in other states as well. And this we should acknowledge. And when we put out India Justice Report, Vijay Raghavan is here, and I'm sure he'll agree with me that we have very many more detention, places of detention of people, including the foreigners being detained. So when we look at all of this, we should not focus, we should not confine our focus, if I may say, use the right expression. We should not confine our focus only to prisons, that is the central jail, the divisional jail, sub-jail, and that, so on and so forth. But detention centers, and I would add to this, all your quasi-penitentiary institutions, penal custodial institutions, like for instance, Nari Niketans, observation homes for boys. In some states, we still have the beggary laws. Some states have abolished, but many states, the beggary laws continue. So you have detention centers where you're keeping people brought under those laws. So you have very, many more. And if I can go further, there are police lockups. And so I think the range of detention centers has increased. And that we should acknowledge. While we say we don't have data, we must say that we don't have data on all these things as well. Like, do we know now in the detention centers in Assam, where the so-called non-citizens have been held, what is the accurate population of those non-citizens? We don't know. And these are not detention centers just in Assam. Like I said earlier, it is in other states as well. So this is something that we need to acknowledge. Third, we've talked of judicial impact assessment. We must talk of prison impact assessment. And I would, instead of using the word prison, I would say detention center impact assessment. We make a new law by which we disenfranchise people, for instance, right? That impact of the law is then you're pushing people into detention centers. You make a very harsh law. I'm talking of not just UAPA, let's say PMLA or even your economic offense laws, where bail is routinely denied, right? As a result of denial of bail, the under-trial population increases. And courts are deprived of the powers to grant bail because the threshold for grant of bail is made so high that prison populations immediately, there's an immediate impact on prison populations. Prisoners can't be released. So this is something that we need to acknowledge in the impact that severe criminal laws or newer laws have on the prison population. Like we cut down on permissions for rallies, right, of processions. And there will be people like farmers' protests, for instance. One event like a farmers' protest can overnight increase the under-trial population in some of these states where the protests are going on, right? Then you have these detentions under sections 107, 151 CRPC, preventive arrests under CRPC. They also land up in prisons. You have in many states the preventive detention statutes, like the Gundas Act in the South, the Public Safety Act, the COFEPOSA. I'm just saying there is a range of preventive detention statutes. Those people also land up in prisons. So if you drew a chart, the flow from various statutes that criminalize activities that push people into prisons. Let's take the Immoral Traffic Prevention Act, right? Children in conflict with the law. I'm just saying the prison system, the criminal justice system, particularly the prison system, you have people coming in because of various oppressive laws, failure to grant bail, failure to post bonds, right? Despite being granted bail, all of that. So once you show it graphically, then we'll know this impact on the prison system. And it's therefore a serious, far more serious problem than simply saying we don't have enough prisons. I wanted to just share with all of you the experience of Odisha. If you go onto the Odisha High Court website, you will find a PIL portal. You will find a particular PIL concerning prisons. And in that portal, in fact, I've had my own young researchers here look at it. You have all the orders concerning the reform of prisons in Odisha. You have the various affidavits filed by the state government giving out statistics. Then you have reports of the amicus curiae appointed by the High Court analyzing those statistics. And for instance, you mentioned the lack of mental health professionals in jails. Actually, there's a lack of mental health professionals throughout the country itself. That's a larger problem. In fact, this prison problem is a smaller, a capsule of that larger problem as far as absence of psychologists is concerned. But how we identified that problem in Odisha, how we tackled that problem in Odisha is very instructive. So while you talk of what states have not done, it's important to say which states have done, how they've done it, and how it has been possible to do it there. Whether it was collaboration, with civil society groups, or with a more, committed kind of set of bureaucrats in those states who felt this to be important enough to pay attention to allocate resources to, or even the prison administration. You've had some very, dedicated IG of prisons in some of these states. So while we talk of the failures of the prison system, there are small pockets. I'm deliberately using the word small pockets where reforms have been attempted, including open prisons, and with some degree of success. It's important to know that there are some places where things have worked, many places probably where things haven't worked. Maybe one should learn from the other. Like when we had this PIL hearings, and Vijayaraghavan is here, Maya is here, they all participated in those hearings. We had those hybrid hearings. We had experts come in, and we have links for those hearings on that PIL portal. So each of those hearings took place perhaps on a Saturday. It went on for 2.5 hours, where there was an active discussion in a non-adversarial atmosphere between the prison administration, the court, and the civil society groups, where you could voice your concern, you could put out what you've gathered as information for them to respond to, and for them to then give you information which you could then respond to. So this interchange, this dialogue was facilitated by the PIL being conducted in that kind of an open atmosphere. And if that could also be looked at as a possibility in different states, in many high courts, the high courts in the PIL jurisdiction are dealing with issues concerning prisons. It's just we need to know what are the better ways of doing that and keeping that as a continuing exercise. You've heard of the expression continuing mandamus. It's important to keep the court in the loop to tell it that what is possible to be done when there's some degree of pressure from the court, with deadlines being fixed and court asking for compliance reports on various dates about steps taken to improve the conditions of prison. So in Odisha, for instance, we could deal with the issue of overcrowding. I'm not saying that we found a complete solution, but we definitely were able to mitigate and find a solution where we could redistribute the prison population without again affecting their capacity to, or their need to come to the courts on different hearings. the issue of quality of food in the prisons, the amenities in the prisons, including medical facilities, and so on and so forth. Issue of denial of bail and failure to produce sureties because the surety amount is fixed so high that you cannot, comply with those conditions. So this is one reason why the prison population has kept increasing in our country. Having said all of this, I must flag 2 or 3 concerns about data itself. While you are absolutely right on unreliability of data, reliable data should be shared, but within the system. In both in Haryana, and this was replicated in Odisha, we have the system of generating what are called custody certificates, right? That custody certificate or the custody report, which is presented before the court, will tell you why the prisoner is in this prison, what has been the track record. That is, how often has the prisoner been released on parole or furlough or granted bail or interim bail, how often he's complied with those conditions, he or she, and how they come back in good time. What are the offenses with which they've been charged? If there is more than one case, what is the status in each case? This entire thing can be generated and presented before the court without too much waste of time. Because when a bail application is filed in a court, the court asks for this information. And if it is available first hand on the first date itself, it saves a lot of time for the court. And Haryana has got an excellent model for this, and Odisha has replicated it in a limited extent. This is possible only if the data is accurate and the data preserved by the prisons is not different from the data preserved by the police. They should tally, they should match. Usually there will be mistakes, for instance, in spellings. Ajay Kumar could be AJAY, or somebody could key in as AJEY, right? So you could end up picking up the wrong person for this kind of a custody certificate. So cleaning up the data, ensuring accurate data is very important. So in Indian system, you always have son of, daughter of, wife of, and all of that. We'll say Ramesh Kumar, son of so and so, is different from Ramesh Kumar, son of somebody else. So otherwise, Ramesh Kumar is such a common name in our Indian prisons. So the custody certificate is something that you need to understand, because that tells you how it materially affects the possibility of the prisoner continuing to remain in prison or being released from prison. There are many prisoners in our system who've completed more than half the sentence which they have been punished. There's a separate provision in the CRPC facilitating their coming out on bail if they completed more than half the sentence. That's now built into it. It came through judgments. It's now built into the statute. There are prisoners who completed their entire term and their appeals are still pending in the High Court. And if we can get accurate statistics, what we did in Odisha was to get the DG prisons to periodically give us statistics of people who've been granted, who completely served their sentence and left the prison system, or prisoners who've been granted remission have left the system and their appeals are still pending. So this way, if there is an active collaboration between the police, the courts, and the prisons, it can help prisoners in a very direct kind of a way. This kind of an exercise should be made mandatory by drawing up checklists for visitors to prisons. That visitor system that we have in prisons is, by and large, I would think, a very ineffective system as it is now. In some states, it is good, but in many states, it's not working. So if we can have an audit, how often do the visitors actually visit the prisons? The district judge is supposed to visit. What is the kind of checklist they have when they enter the prisons? Now, what should they be looking for? What should their reports contain? When CHRI intervened, I think the prison matter, Maya will recall, I think you suggested a certain format for submitting report on visits to the prisons. If that can be systematized and then made compulsory for all visitors for all the prisons, that will again help very much. My concern, and this is the point I'm trying to make, that all this data gathering, data analysis must ultimately help people in prisons. It must help actually improve the system of prisons. It must help prisoners. And there are others, non-criminal residents of prisons, like children of convicts, children of under trials, right? So we shouldn't forget those larger categories. And like I said, the women who are seemingly, purportedly being protected by being kept in Nari Niketans, invariably against their choices. So there is this larger population that we need to address ourselves.